And of course, since the start of that strike a week ago, we have seen that some people wanting to work in the health facilities have been barred or threatened. The health minister himself saying that at least 4 people have died in this action. To discuss, we're now joined by the head of employment at Cliffe Dekker Hofmeyr, that's Aadil Patel. Mr. Patel, thank you for being with us. Let's just look at the response of Nehawu now, that it couldn't get this interdict overturned. It says in the next 72-hour window it will comply with the court judgment while it explores options to push back. Does the court give it a 72-hour period to comply? How does it work now?
So firstly, let's just understand what the court judgment states. It indicates that essential service employees are prohibited from embarking on industrial action. That has always been the situation. The Labour Appeal Court has simply confirmed that, and Nehawu had until 1 o'clock to inform its employees. However, employees who are not part of an essential service in the public sector are entitled to embark on industrial action as such. So if I may, the appeal was successful in part and unsuccessful in part. And the court order specifically says the appeal succeeds in part with no order as to cost. So just to reiterate, employees who are not part of an essential service in the public sector may embark on industrial action.
All right, thank you for clarifying that. So it is the essential service workers who have to get back to work. What does this empower government to do if they don't by tomorrow, the next day, for example?
So in relation to those employees who do not return to work, government may certainly embark on contempt proceedings against those identified employees. It can also institute disciplinary action against those identified employees. And I'm stressing the word identified because you would need to identify those employees. It could potentially also institute a civil claim against the trade union insofar as it doesn't adhere to the court order, complying with the court order, informing its members to return to work as such. Those are government's options in respect of this.
I think one thing many South Africans don't understand is why we have laws around essential service workers. So there are staff deemed to be very important that they are not allowed to take off for any sort of industrial action. But there's always a court case thereafter, the strike begins. I mean, why couldn't government move quickly from day one, say, and identify nurses possibly that were participating in the strike and immediately start disciplinary action? Why is there always the delay with the interdicts, or is that just a legal guarantee, as it were?
So employees, it's common that employees, the law is quite clear. Employees embarking on who are essential service workers cannot embark on industrial action. Those employees know who they are, but despite that, they proceed with unprocedural and unprotected action. In this particular situation, and it's something that I need to put forward, is government came and indicated that they tried to attack or declare the strike illegal by saying, we do not have money to meet any of Nehawu's demands, and therefore the strike must be declared illegal, and the court put short shrift to that. The fact that you can't afford it does not mean that employees cannot embark on strike action, and those relate to non-essential workers. Certainly, essential workers who know who they are because they're identified by the Essential Services Committee or in terms of various collective agreements or because of the positions they hold, would know who they are, would know that they're not entitled to embark on strike action, and thus the necessary action may be taken against those employees. I want to indicate that the court, despite saying that employees who are non-essential may embark on strike action, was scathing in the fact of the wanton violence and intimidation and the like, and said that we must take firm action against those individuals who commit acts of violence. Acts of violence and intimidation have become the hallmark, as our courts have said, of industrial action in South Africa. It seems that we believe that the more violence and intimidation we cause and destruction, we will come to the party. Yeah. Government has clearly indicated, as elucidated in the court judgment, that it certainly does not have the money to meet the union's demands.
We're running out of time. Very quickly, let's look at those demands and what's going to happen at the end of March, I understand, because last year government said it had no money. It would unilaterally impose, I think, the 3% increase and the 1,000 Rand or whatever it was, depending on what you earn, but a non-pensionable allowance. Now, I think Nehawu is particularly concerned that that falls away if there's no new agreement. Can you just confirm what happens to that non-pensionable allowance?
So government would simply unilaterally implement if the collective agreement pursuant to which these benefits were granted lapses. They're not entitled to those anymore because the parties were needed to conclude an agreement regulating it further.
All right, thank you. We'll leave it there. Head of Employment Department at Cliffe Dekker Hofmeyr, Aadil Patel. And let's see what happens now. So the court affirming that non-essential workers can continue with the strike action. Essential workers are due back at work as they were right from the beginning of the strike action.